Let's shift focus and bring you the other big story for you from the weekend gone by. The IEC says it's investigating how the candidate lists of a number of parties were leaked to the public from its database. Political organizations that are hoping to contest the May elections had to meet a deadline to submit their list to the IEC by Friday. But just hours later, that information had hit social media with the personal information of some candidates widely circulated. This incident has raised questions about the provisions of the Protection of Personal Information Act, otherwise known as the POPIA, and how it can be applied during the election season. Let's get you a sense of what to think about. Bring in Adv Tshepo Boikanyo, who is the executive in charge of the POPIA with the Information Regulator, and joins us now via our video link. Advocate Boikanyo, it's lovely to see you. Thanks very much indeed for making time. An incredibly important issue, this, and I wonder as a start if we can speak about the compliance framework that the Information Regulator expects the IEC to adhere to, especially during an election period.
Good morning, Ayanda, to you and your viewers. And at the very outset, let me indicate that there's an obligation. Any person that holds personal information has an obligation to ensure that it protects the confidentiality of that particular information that it holds. And this is in accordance with POPIA, as you've rightfully stated, specifically Section 19 of POPIA that says that any responsible party must protect the integrity of that information by ensuring that they have technical and organizational measures in place to ensure that there is no unlawful access of that personal information. And to this extent, that is the reason why there's a further obligation that is then placed on any responsible party that would have a compromise of personal information and the unlawful compromise of personal information. Section 22 places on an obligation on that responsible party to notify the regulator, and specifically Section 22(1), not only the regulator but also to notify the data subjects whose personal information would have been unlawfully accessed by a person that is not authorized to access that personal information.
Given what you've just said, the presumption here is that the IEC is meant to be in touch with yourselves as Information Regulator to give an explanation at the very least around how this happened.
Indeed, and maybe let me just sketch the background for the benefit of the viewers. On the 8th of March, we received a notification from the IEC that there had been 2 security compromises in relation to the personal information that it was holding, and specifically the candidate lists of 2 parties, the ANC and the Umkhonto weSizwe party. Against that backdrop, and we had to then perform an analysis or an assessment of the notification. And when we did that, we then picked up that this particular notification that is sent to us in accordance with Section 22 of POPIA was not compliant with the provision of Section 22(5) in a few respects. And we then directed an information notice to the IEC. That an information notice is a notice that will then compel the IEC to provide us with additional information so that we can map out the course that we need to take as a regulator insofar as this particular security compromise is concerned.
And what does that map work look like, if you're able to speak to us about that, Advocate Boikanyo, especially because the information is already out there, and in some instances, people's IDs, for example, were widely circulated. It's difficult to think of what remedial action looks like in a space like social media where there are so many different actors pulling in so many different directions.
Well, maybe I need to start off by saying that in terms of Section 22, there are certain things that are circumscribed by the Act. One of those is that the data subject, when they notified, it has to be in writing, and the notification to the data subject must be placed in a prominent position, for instance, on the responsible party's website, in this instance on the IEC's website. But there are further requirements that are circumscribed in Section 22(5) of POPIA, in a sense that the IEC should give us a description of the possible consequences for the security compromise and the measures that it has taken to mitigate that security compromise, and also provide us with information relating to whether there are adverse effects of that particular security compromise. In this instance, the IEC only, insofar as the ANC notification is concerned, only provided us with information pertaining to the number of data subjects that had been impacted on, which is 204. But in relation to the Umkhonto we Sizwe party, it did not provide us with the numbers of the data subjects that had been impacted on. Now, just to go back to your answer, once we've received this information, we will then map out the way forward, which we would consider whether there are additional steps that we should be taking, and this would be informed by that particular information. But in terms of the assessment that we conduct, we look at the impact that the security compromise has had and the consequences, and whether it was an isolated incident of a security compromise or whether there had been security compromises before, and that would inform us on the cost to take, and the cost to take might vary depending on the information that we receive as the information regulator.
Yeah, we do know, of course, that sharing people's personal information without their consent, even if you weren't the initial publisher, can make you susceptible to be in breach of the POPIA. And I suppose you can speak to us a bit more about that. And I'm only prefacing my question with that because, a number of people have retweeted it. A number of prominent journalists as well have made sure that this is available to the public. And I can imagine, Advocate Boikanyo, part of the argument that they're going to make here is that sharing the information is in the public interest. And that's going to raise questions about balancing these two things, the provision of the POPIA on the one hand, and of course, the principle of what is and isn't in the public interest.
Well, indeed, but I think I should hasten to say that when anybody processes personal information, they have to do that in accordance with the 8 conditions related to the processing of personal information that are contained in the Act. And the rights of the data subject have to be equally protected. Now we're talking about unique identifiers that has been processed, and unique identifiers would be your ID number. It's a number that is unique to a particular data subject. One of the things that we would consider, yes, you're correct, is whether the issue of public interest may come in. But we, as a regulator, we have a responsibility to ensure that we protect the personal information of a data subject. And when that information, and maybe the argument may be made, Ayanda, that in any event, the list would have been made public at a later stage. But remember that there are certain processes within the IEC that have to take place. And it's only an authorized person that can then publish that particular information. You cannot at the particular stage say, well, but we publish, the information is out there, and in any event, it would have been made public to the members of the public. There are certain things that are circumscribed, and POPIA, there are certain requirements that have to be met in terms of POPIA before that information is then published.
So then what's your advice as a regulator then around the continued sharing of these lists? Is that advisable? Should that continue?
Remember that when personal information is processed, one of the 8 conditions is that it has to be for a specific purpose. Now, the specific purpose was for the IEC to consider the names, and once it has then considered the names, then it has to take the necessary, it has to then act in accordance with the processes, its own internal processes. Now, the continued sharing of this personal information is further processing, and it's contrary to the 8 conditions for the lawful processing of personal information as circumscribed in Chapter 3 of POPIA. So that is highly discouraged, because you would further be breaching the conditions of POPIA.
Right. Given what's taken place, I mean, and I should probably say as a start that this is not fear-mongering in any form, but it's probably popping up for many prospective voters. We know that anybody who has to vote in this country has to part with significant information, IDs, addresses, cell phone numbers in some instances. And there might be questions around how worried people should be about there being yet another security breach that may lead to their information being spread in this way. In your conversations with the IEC, how confident are you that they'll be able to avert any of that happening? Well,
and I would not want to venture to speculate, because in the in the security compromise that the IEC sent to us, the IEC indicated that there is still an internal investigation that is being undertaken, which would then also inform the decision that we are going to take, excuse me, as a regulator. Now, what I can say, and maybe the advice that I can give to data subjects, is that they have a concomitant duty to ensure that they also safeguard their own personal information. Because once you make your information public, or your information is out on a public document, it can easily be accessed. Remember that Section 12 of POPIA stipulates that information has to be obtained directly from a data subject, and there are those exceptions that are stipulated under subsection 2 of POPIA, that one of them being if it's, for instance, in the legitimate interest of the data subject, and if there's a contract, and I'm not going to go through all of those exceptions, but just to sound caution and say that any responsible party that also has or is in possession of personal information of a particular data subject has to ensure that it protects that particular personal information, the integrity and the confidentiality of that personal information. And once the IEC reverts back to us with the information that we've requested in the information notice, we'll be able to make the determination of whether there were adequate safeguards to protect the personal information of those candidates that were on the candidates list, or whether this was a once-off incident. And in us coming to a decision or a determination, we would have regard to all those factors in accordance with our decision metrics.
Well, fair enough. Advocate Boikanyo, thanks very much indeed for speaking to us. Really do appreciate your time. It's also a great opportunity, I suppose, to speak a bit more about the POPIA and its relation to the elections, and I think we've done that relatively well. Advocate Tshepo Boikanyo is the executive in charge of the POPIA with the Information Regulator. Once again, thanks very much indeed for your time.